Thank you. The gentleman yields back, and the chair recognizes Mr. Kiley for 5 minutes.
I yield my time to the chair.
Thank you for yielding. I got to go back to Mr. Hsu because I had some more questions. I mentioned a moment ago that I started tracking this during the Obama administration, but as you noted, it goes back at least to the Carter administration. So that was a little before my time. But what is your best guess? Well, let me say this. One study that I looked at said that only 1.4% of all settlement slush fund payments can be tracked. So that means 98.6% of the $668 million that was that this calculation was directed in ways that were undisclosed. So we have no oversight ability at all over that. What's your best guess for how much money has been diverted through the settlement slush funds? And I guess this could go back to the 70s, right?
We're talking in the tens of billions, Congressman.
With a B, billions.
B.
Wow. I had a list of some of the Obama administration examples of this, where settlements were directed funds to the groups like National Fish and Wildlife Foundation, National Community Reinvestment Coalition, National Urban League, National Council of La Raza. In your mind, what are some of the more egregious examples, or can you name some of the beneficiaries of these funds over the years?
Yes, certainly the ones that you mentioned were beneficiaries. There were also, even local to Washington, D.C., you know, there was the Voice group and the Metro IAF in Virginia. They actually, not only did they lobby the DOJ, they also lobbied Mark Warner to help them get these settlement funds. And, you know, it's not an accident that every single entity who received the largesse of improper third-party payments was a liberal group. Now, you could say, well, it's because the Obama administration is Democrat. Yes, I understand that. But there's also an email that former Chairman Goodlatte had uncovered, where you have the acting senior counsel for access to justice programs at DOJ writing to the principal deputy associate attorney general. And she said, concerns include, A, not allowing Citi to pick a statewide intermediary like the Pacific Legal Foundation because it does conservative property rights, free legal services. I mean, come on. And I'm not saying it's bad or good. You know, as I mentioned, Chris Christie was awfully partisan himself. So I'm saying that either way, from either point of view, it's not right. And it's offensive to Congress's power and authorities.
We agree. Ms. West, I want to go to you. I love your a picture's worth 1,000 words. I think there are actually 1,000 words on this chart here. And for those who might not have seen your opening testimony, this is in the record, but this is entitled "The Convoluted Process Property Owners Face When Their Property is Seized for Federal Forfeiture." And it is there's no way that, I mean, I'm a lawyer and this is hard for me to follow, and so it's difficult for citizens to do that. It's difficult for us to track and oversight and all the things we're talking about. To summarize your testimony, you said this is a trapdoor for the protections of the Bill of Rights, and you said you gave three recommendations: end administrative forfeitures, end financial incentive for forfeiture, which is send all this to the general fund instead of these other things, and then inequitable sharing. So real quick, with a minute, 90 seconds, if we were able, the FAIR Act has all this in it, if we were able to pass legislation to check each of those boxes, what would this chart look like after that? Would it simplify it dramatically?
Not only would it simplify it, it would take away this whole half of the chart.
Oh, wow, okay.
So anything under administrative forfeiture, if we end administrative forfeiture, all forfeitures will happen where they should happen, which is in a real court, a real Article III court.
Excellent. Mr. Grossman, you said that the sue and settle issue really exploded under the Obama administration. Do you have a theory as to why it began? Why is this such a recent advent in the law, or a recent practice?
I think the political dynamics really do explain it. Many of the groups bringing these suits are pro-regulatory groups. They had discovered that they could use the leverage of litigation to lead to favorable settlements at the tail end of the Carter administration. There was a little bit of activity along these lines during the Clinton administration as well, but it was really during the Obama administration that it exploded across the board, not merely in the environmental space, but really affecting any number of different federal programs and agencies.
And it started a custom and practice, and the only way to reel that back in and change it, in our view, is if Congress acts and has to do this. So that's why we appreciate your testimony so much. I remember from law school the term vexatious litigation. It feels that way. It feels like that. The chair is out of time, and I recognize next